Good afternoon, everyone. Today, I have the pleasure of introducing our panel on conflicts and arbitration. This panel will explore the growing intersection between geopolitical conflict and international arbitration, an area that has become increasingly central as global tensions and armed conflicts reshape the legal and commercial landscape. Bringing together perspectives across both public and private international law, our panelists will discuss how tribunals are responding to disputes arising in contexts of heightened instability and how practitioners and their clients are navigating novel procedural, substantive, and enforcement challenges. The panel is structured around 4 key themes: the evolving role of conflict and investor-state disputes, its impact on commercial arbitration, the practical and procedural complexities unique to conflict-related cases, and finally, the challenges of enforcement and execution in an increasingly fragmented and sanctions-driven global order. Before I turn it over to the panel, I am thrilled to introduce Paris Aboro, our panel's moderator. Paris is special counsel in Covington's London office, advising on complex international disputes. She previously served as legal advisor to Judge Thomas Johnson at the Iran U.S. Claims Tribunal and practiced as a barrister in London. Paris teaches international investment law at Columbia, from which she also holds an LLM. Please join me in giving a warm welcome to Paris and our panelists, Ank Santens, Andrea Bjorklund, Daniel Reich, and Andrew Finn.
Hello, everyone. Hopefully you can hear me. Thank you, of course, to Juliet for organizing this panel today, to the Columbia Arbitration Day organizers. I know how much work goes into organizing this conference, and taking on 2 days of the conference is certainly admirable, and it seems like it's gone off extremely smoothly, so congratulations. Thank you as well to Columbia Law School for hosting us today in the beautiful Low Library. And of course, congratulations, Professor Berman, on your 50 years at the law school. So as Juliet previewed, today's discussion is focused on issues arising in the specific context of arbitration disputes that emerge against a background of conflict or heightened geopolitical tension. Of course, unfortunately, I don't need to explain why a panel like this is relevant. I also can't articulate in any more eloquent or persuasive terms than those that have gone before me the importance of our continued commitment to the rule of law, which must include the international rule of law. Luckily, in a room full of lawyers, I hope that this doesn't take too much persuasion. In the course of my career, since I left my LLM at Columbia, I've had the solemn privilege of acting in some of the kinds of cases we'll be discussing today, seeking to hold states that violate their international legal obligations accountable. The work of lawyers in times such as the present is as important as it ever can be, and for the students in the room, I hope that your time at Columbia and the opportunity to attend events like this affirms your choice to pursue a career in law and hopefully in international arbitration. So with that somber introduction out of the way, and as you can see on the stage, Juliet has assembled a truly exceptional lineup of panelists to help walk us through some of the particularities of conflict-related disputes. As you heard, we're joined by Professor Andrea Bjorklund, full professor and the LU Fortier Chair of International Arbitration and International Commercial Law at McGill University Faculty of Law. She is also the general editor of Arbitration International and for investment for the Journal of International Dispute Settlement. And in addition to her academic work, she acts as an arbitrator and an expert in both investment and commercial arbitrations. Next to me, we have Dan Reich, a partner in Paul Weiss's International Arbitration Group. He represents clients in complex international commercial and investment treaty arbitration across a range of sectors. He brings to our panel today over 20 years of experience advising states, state-owned entities, corporations, and individuals in arbitration and public international law matters, in US litigation, and in domestic and cross-border government investigations. Next to Andrea on the end, we have Ank Santens, global co-head of White & Case's international arbitration practice. She also acts as counsel and arbitrator in commercial, investment, and construction disputes around the world, and her clients include companies and sovereigns across Europe, the Middle East, Latin America, and the US. Ank is also a member of the ICC Court of Arbitration on behalf of Belgium, is a board member of the NIAC, and holds other leadership positions in the community. And finally, we have Andrew Finn, a partner from Sullivan and Cromwell's litigation group and the head of international arbitration and global dispute resolution practice. Andrew's practice focuses on multi-jurisdictional and transnational disputes, both in arbitration and US state and federal courts. He has litigated a variety of cases, from commercial and investor state arbitrations to securities, class actions, and other significant contractual, bankruptcy, and competition cases. So a wealth of experience to speak on today's topic. Thank you all for being here, and I hope that today we have a fantastic discussion. So we have just over an hour for our discussion, and we'll reserve time for questions from the audience. But with the introductions and formalities out of the way, I will hand over to Professor Bjorklund to address our first topic, the evolving role of conflict in investor-state disputes. Professor Bjorklund.
Thank you very much. Thank you to the Columbia Arbitration Day organizers for the invitation to join you. What a pleasure it is to take part in this celebration of George, not just of his exceptional career, but of him as a person. It is an honor to have him as a colleague, and even more so to count him as a friend. When we talk about conflicts and investor-state dispute settlement, I think of two main general areas. One is the war in Ukraine and several other conflicts, and the associated cases arising out of that conflict and the difficult international law issues they have raised. The second is the constellation of issues orbiting around the issue of sanctions. But if we think more broadly about areas of geopolitical concern, I would add matters of economic nationalism to that list, and even potentially climate change. So I'll first talk a little bit about the kind of territorial, I think of the territorial issues, but insofar as the conflict, the actual war conflict cases are concerned, as exemplified by Ukraine in particular, you know, they raise in the first instance difficult questions about territory. Does Russia's occupation of territory make it responsible for acts occurring on that territory? To decide in the affirmative, do tribunals have to recognize Russian occupation? If they recognize it, does that somehow render it more lawful? Generally, tribunals have avoided ruling on the legality of Russia's invasion of Crimea. Those are the cases that have been decided. Instead, they have found different means of recognizing their own jurisdiction by focusing on the effectiveness of the control and the concomitant responsibility of Russia, rather than on the lawfulness of the occupation. These cases also raise questions about so-called war clauses, provisions in some treaties specifying how investment should be treated during times of war, and the types of protection to which they are entitled. One preliminary question is whether the Russia-Ukraine conflict should be described as a war, or is it an armed conflict? If it is the latter, does that make a difference? Does that change the applicability of a so-called war clause? I feel like today I don't need to suggest that we're going to see similar debates in future about excursions into various territories in the world. What about effective civil wars, such as conflicts within Libya, to shift geographic locations for a moment? Is that a difference from a war? Does that mean the war clause applies or doesn't apply? How do war clauses interact with other bilateral investment treaty provisions? Do they displace them? Do they complement them? Do they apply during the war or armed conflict? And do they cease to apply after? And does the rest of the bit, I guess, revert to its applicability? So we have those questions about kind of straightforward treaty interpretation. Maybe not straightforward, but treaty interpretation. But more broadly, the Ukrainian situation raises questions about the use of investor-state dispute settlement as a tool in an international conflict. In response to Russia's invasion of Crimea in 2014, Ukrainian officials encouraged investors, especially those that were SOEs, to initiate a coordinated lawfare strategy wherein they launched ISDS claims against Russia for actions that took place in Crimean territory. As Columbia law professor Eric Chong noted, the Ukrainian Ministry of Justice published its Lawfare project website, which is no longer live on the internet but was up for a while, in which it said the following. One of the key areas of confrontation is the legal one. The legal front is inconspicuous but extremely important. Its key feature is that there is no noticeable disproportion in weight with the enemy. It is not subject to force-sharing agreements. Where there are no weapons, there is international law, sanctions, and a tribunal. In the West, legal war received a special term, lawfare. And on this front, Ukraine, comprising state bodies and state-owned enterprises, is fighting quite well. The second general area I want to address is sanctions. Now, we have heard quite a lot about sanctions over the past few days, so I won't repeat those discussions. I would just note that the question of sanctions not only affects investor-state arbitrations in much the same way they affect commercial arbitrations, but they can also themselves be the topic of an investor-state claim. In January of this year, a Moldovan billionaire filed an investment claim against Canada under the Canada-Moldova BIT, challenging Canada's decision to include him on its sanctions list because he does business in Russia. He claims Canada's decision has deprived him of his investment in his Alberta company called Spartan Delta because he cannot dispose of his shares or receive dividends. He's also challenging his inclusion on the sanctions list. He did challenge it in front of the minister, but to no avail, because the Minister of Foreign Affairs rejected his request to be removed from the list. He challenged that decision in Canadian courts, but the courts essentially said this was a political question not reviewable in Canadian courts. So he is claiming national treatment and most favored nation violations, fair and equitable treatment violations, including denial of justice and expropriation. Very new, filed in January, so it will be a while before we see where that goes. Now, certainly these areas are likely to remain important, but other areas of geopolitical concern are likely to arise with respect to economic statecraft surrounding matters such as supply security in the area of energy, however it is derived, and critical minerals, to name just two essential areas where states are increasingly concerned to transition away from concentrated supply chains. Indeed, in this era of geopolitical rupture, in the words of Mark Carney, more states are more protectionist as a matter of essential security. And the notion of what is essential can be quite capacious. Energy supply, critical minerals, iron, steel, aluminum, food, military equipment, semiconductors, ships, to name just a few. Changes to law and or policies to facilitate and effectuate essential security will likely lead to investment cases, and I think we can anticipate that states will defend themselves on the grounds of essential security. These cases are going to give rise to inherently contentious and politically fraught judgments for tribunals. The United States has several treaties that purport to make the essential security provision non-justiciable, that if it is raised at all, if the United States says essential security, then the tribunal loses jurisdiction. They cannot consider it even on good faith grounds. Now, those provisions have not been tested. Will they be? Even if those provisions are not at issue, how to apply and assess essential security interests or the state of necessity at customary international law is not easy. As we know, tribunals in the Argentine cases took at least 3 different approaches to the essential security provisions and the state of necessity defense at customary international law. A sidelight, just a side observation, is that cases involving military or other essential security interests might be less publicly available than other cases. The trope that investment treaty arbitrations are secret continues to be repeated, notwithstanding quite a lot of evidence to the contrary. We have quite a lot of transparency, but that could be challenged if we have a lot of really contentious and, I would say, secret issues arising in these cases. I continue to believe that ISDS can serve as a tool to preserve the rules-based legal order, despite the onslaught of challenges from different directions. I think this might be true in both the guise of traditional ISDS, and even if we see a multilateral investment court, as we were assured yesterday that we would. They're likely to operate in parallel for a significant period of time. But it does seem to me that in either guise, investor-state arbitration's attractiveness as an alternative to gunboat diplomacy is heightened just now after recent events in Venezuela and Iran, to name just 2. I think, we should be realistic about what investment arbitration can and cannot do. It cannot solve democratic deficiencies in host states, or in home states for that matter. It cannot create obligations that states have not seen fit to undertake, or to create for those operating within them obligations that don't otherwise exist. Yet it also cannot excuse states from their obligations in furtherance of amorphous policy goals. I don't think we can ask too much of investor-state dispute settlement in a world of protectionism and realpolitik, but I continue to believe that rules-based dispute settlement is an improvement over the alternative. Investment treaty arbitration, yes, so I think I'll stop there. I do think that tribunals are going to see increasingly contentious and politically fraught cases, and that we will have a lot to talk about at Columbia Arbitration Days in the future.
Thank you, Professor. I think it's interesting the point you note about the challenges that tribunals are going to face when confronted with defenses by states that are taking reasonable measures in the interests of their national security, particularly in circumstances, or any other essential security interest as the case may be, but particularly in circumstances where treaties may not include a specific exception, for example. So thank you. You also mentioned the overlap with commercial arbitration and sanctions, and with that, I'll hand over to Dan to take us through that.
Thank you, and just a word of thanks to Paris for steering our discussion, to the organizers of Columbia Arbitration Day for putting all this together. It's a fantastic conference that's really become a staple of the New York arbitration calendar. And it's really a privilege and honor to be here this year to celebrate Professor Berman and his enormous and invaluable contribution to international arbitration, and particularly to the New York arbitration community. So I'm really delighted to be here. So picking up on a theme that Professor Bjorklund was referring to, which is geopolitical rupture and the fact that more states are increasingly protectionist. I'm going to focus my remarks, which are really focused on commercial arbitration. I'm going to talk particularly about the changes in the global economic order, which is undergoing a fundamental transformation. And I think that's very part and parcel of the world of conflict and increasing geopolitical tension and risk that we're seeing that's impacting commercial transactions every day and more and more. That transformation really carries profound consequences on how commercial transactions are structured and negotiated and how disputes are initiated and litigated. And what we're witnessing is a world where coercion is happening not only through gunboats or warships, but through sanctions, as Professor Bjorklund was discussing, but also tariffs, export controls, and national security review mechanisms. And these are tools of economic statecraft that have become primary instruments through which states are exerting pressure on one another. What was once an era of open markets, predictable rules, and stable dispute resolution mechanisms is giving way to a fragmented landscape with new challenges that are really unprecedented. So how do geopolitical tensions and hostilities impact international arbitrations, particularly commercial arbitrations? I'm going to focus a little bit on the rapid expansion of sanctions regimes and how that's impacting disputes, and then also export controls and national security review mechanisms. The issues are live, they're impacting practitioners, arbitrators, institutions, and it's important to take opportunities like this to think collectively about how we address them. So, of course, with sanctions, we've seen a proliferation of sanctions regimes, particularly with Russia after the Crimea crisis and the expansion of sanctions after the invasion of Ukraine. And then interestingly, and something that presents a real challenge to certain arbitral tribunals are blocking statutes. And so we've seen the EU's blocking regulations forbidding EU operators from complying with certain US sanctions, for example, placing European companies in an impossible bind where complying with US law risks EU enforcement violations. China similarly has responded with its own anti-foreign sanctions law and counter-sanctions framework, and I'll come back to that in a bit. And on national security review mechanisms and export controls, we're seeing those impacting transactions every day. The proliferation of national security and CFIUS practices in this city is just a testament to how relevant it is to the work that we're doing. And a particular challenge there is that the scope of what is deemed national security is becoming broader and less precise. And Professor Bjorklund has talked about how that impacts investor-state disputes, but it also is coming into play in commercial disputes as well. Particularly in the United States, where CFIUS is playing an increasing role in review of transactions, and where the CFIUS powers have been expanded, particularly in 2018 with the Foreign Investment Risk Review Modernization Act, which has given CFIUS a whole new mandate. And that ties into export controls, where the United States has constructed an elaborate export control regime targeting advanced technologies, particularly semiconductors, anything affecting quantum computing, and what they call additive manufacturing, such as 3D printing, which has applications in nuclear military applications as well as conventional military applications. So, how does that impact arbitration? I'll touch on a few points, and I'd like to really come to a few concrete examples to really focus a lens on this. So, in terms of sanctions, there's obviously a big discussion, and I'm going to leave it to Andrew and Ank, who I think are going to come to it in a bit more of a robust way. But there's a threshold question, which is are some disputes even arbitrable when sanctions are involved. The prevailing view is that disputes involving sanctions are arbitrable, and even though sanctions have a public policy character, that does not render disputes involving sanctions non-arbitrable. And I'm gonna just kind of go with that because I don't want to impinge on some later discussions. But it's a big topic, and it's affecting commercial arbitration more and more. Substantive. So let's talk a little bit about the substantive issues. And of course, you have the implication of force majeure provisions and hardship provisions, which can be triggered by lots of these measures, particularly sanctions regimes, which do sometimes provide real obstacles to compliance with commercial obligations. But we've all been involved with, and I see some people in this room that I've been involved with in disputes involving geopolitical conflicts that gave rise to force majeure claims, and the central disputes in those cases are often, is the geopolitical conflict really an issue of causation that gives rise to a breach of contract or not? So there's the bona fide reliance on these issues and the mere excuse. And that also ties into issues like export controls, where parties sometimes will rely on other regulatory mechanisms tied into national security, like the National Security Review Mechanism, where parties sometimes use those mechanisms in order to scuttle deals as a mere excuse and not just as a real obstacle. And that's a real issue and live issue that tribunals have to confront, and it's quite a sensitive issue in some cases when you're talking about nuclear technology or military technology that really does have a national security character. Just to talk about a few interesting cases that I thought exemplify some of these issues. We've heard a lot about the Russia constellation of cases, and so I won't focus on that, but of course those are relevant. China, of course, as I mentioned, has an anti-foreign sanctions law, and in November 2024, there was a case out of the Nanjing Maritime Court where a Chinese manufacturing marine engineering company was placed on the OFAC, specially designated nationals list, for alleged violations of sanctions, and then a foreign equipment supplier refused to pay an amount that it owed to that entity for work that it had performed. And then the Nanjing court essentially issued a preliminary injunction freezing a vessel and forcing compliance with the monetary obligation. And in the interest of time, I'll cut to the chase, which is that the Chinese court found that it had jurisdiction even though there was an arbitration clause, because Chinese parties have a right to sue in Chinese courts where foreign restrictive measures are implicated. And so we see this tension between these blocking statutes and these measures that states are taking to counter sanctions regimes. There's another case, it's a Delaware Chancery case that I just want to mention from an opinion that was issued last year. It's Desktop Metal versus Nano Dimension Limited. And I reference it because it really, I think it exemplifies nicely how export controls really come into play in commercial transactions. And even though it's not an arbitration case, it very well could be. And I think it's something we all need to be attuned to. And it's a case where Desktop Metal Manufacturing, which was producing 3D printers for sensitive applications, including nuclear, missile, and satellite programs, was subject to a transaction that was labeled a high-risk CFIUS transaction. And the merger agreement, the parties were aware that there was this issue, and they negotiated what they call a hell or high water clause. Come hell or high water, you are going to follow through on the obligation to follow through with the CFIUS requirements and to have a national security agreement. And then an activist stockholder came in and essentially failed to comply with that obligation, scuttling the deal and giving rise to a broken deal claim. And so the aggrieved party went to the Delaware Chancery Court and forced specific performance with the requirement to do that. And I think it raises an interesting question. Delaware Chancery Court, of course, is the favorite place for someone trying to get a deal done and to fulfill a closing condition. But it raises interesting questions about what an arbitral tribunal would do with a case involving that kind of sensitive national security issue. And I think my time is coming to a close, so I will just finish with some concluding thoughts on this, which are that I think this world that we're in of what's essentially a new economic order, which is facing unprecedented national security interventions, is really presenting new challenges to tribunals. Tribunals are being asked whether a national security agreement can be ordered through specific performance. Countries like China are asserting jurisdiction over sanctions-related disputes, notwithstanding arbitration clauses. We heard earlier today that the Court of Justice of the European Union is developing a framework for suspending claims during the life of sanctions in the Ribel case. And we have a world of overlapping regulatory interventions across multiple jurisdictions that come into play in standard commercial arbitrations. So the challenges to all of us as practitioners, as arbitrators, to the arbitral institutions is very real, and it requires some very careful thought and activist intervention. The coming years will test whether international arbitration can adapt to the pressures of this increasingly fractured economic order, or whether the fracturing will erode the foundations of the system. Thank you.
Thank you, Dan. I think between you and Professor Bjorklund, it's very clear the complexity that these kinds of disputes really generate, and that the new economic order, as you noted, is really giving rise to. Well, you also mentioned the relationship between domestic courts and arbitration in this context, which again is fortuitous because Ank, I think, will be speaking to that in her presentation on some of the practical and procedural complexities that these disputes are generating. So, Ank.
Thank you, Paris. It's great to be back at Columbia. I am a very proud alumna of the Columbia Law School. I would like to thank Professor Berman because his class on transnational litigation and international arbitration, as it was called at the time, really gave me a very significant desire to practice in the field, which I've been fortunate to do for all these years. I'm also very grateful to the other giant that Rob Smith mentioned yesterday, Hans Smith. The law school has really been, for me, a very defining moment in my career, and always very happy and grateful to be back. Columbia Arbitration Day did not exist at the time at all. So congratulations also to the student organizers for putting on such a terrific event. Really, really impressive. So I have the fortunate task of describing for you some practical and procedural issues that have arisen and we can expect to arise in arbitrations related to conflict situations. You won't be surprised that there are a couple, and you will also not be surprised, given what you've heard already today, that many of them have arisen in the context of Russia-related arbitration, whether in relation to the conflict in Crimea or in relation to the war in Ukraine. But there have also been issues in other cases involving other regions in the world, including Asia, the Middle East, and Latin America, and I'll touch on a few of those in my presentation. The 6 main issues that I have seen are the following. 1, access to arbitration and therefore to justice. 2, parallel proceedings and anti-arbitration injunctions. 3, the question of the non-participating respondent, in this case, the non-participating respondent state. 4, tribunal constitution and arbitrator challenges. 5, issues regarding who is the valid representative of a state in a given case. And 6, and finally, but not least, evidence gathering, as you will have guessed. So I'll try to cover each of these briefly. First, as I mentioned, a serious question has arisen as to whether sanctions imposed on nationals from a country involved in a conflict may prevent them from having their day in court, in arbitration, including in relation to disputes that are entirely unrelated to the conflict. That issue has arisen quite sharply lately in Russian-related arbitrations. To give you one example, a recently reported case was a case before the Singapore International Arbitration Center that was a commercial case relating to the recovery of a debt, had nothing to do with the conflicts, but the Russian party in that case, the Russian claimant, became subject to sanctions as a result of the conflicts and could no longer pay the arbitrator fees and a security for costs. And after a long saga, the tribunal in that case applied Article 32.2c of the UNCITRAL model law, which has been enacted into law in Singapore. And that provision says that if the arbitration is impossible to be continued, the tribunal has a duty to terminate it. So the tribunal found that it was, and I quote, duty-bound to terminate the arbitration. It did so. The claimant appealed to the Singapore courts and that decision was affirmed. Now, I found this quite remarkable because the claim, the debt recovery claim, was subject to a quite short statute of limitations, which had run in the meantime. And so the decision to terminate this arbitration effectively prevented this claimant of a claim. The issue as to how to deal with parties that are subject to sanctions has arisen more broadly in international arbitration. I remember a few years ago getting a call from an arbitral institution that I'm very active in, asking if White & Case could help pro bono with answering some of these questions. Can they actually take the case? Can they get deposits? These are very intricate questions that can raise very practical issues. And just by way of one example, the Stockholm's Chamber of Commerce, which hears a lot of cases involving Russian parties, actually has issued explicit guidance on how to deal with cases involving sanctioned parties. Now, that brings me to my second topic, which is the topic of anti-arbitration and anti-suit injunctions and parallel proceedings. In view of the types of developments that I described and other reasons, in June 2022, Russia adopted provisions in its arbitration code that allow the courts of Russia to assert exclusive jurisdiction over a dispute, even if there is a valid arbitration, otherwise valid arbitration clause in the contract, on the basis that Russian parties do not have their day in court in international arbitration. And that statute has been relied on quite significantly by the Russian courts in the years since to assert jurisdiction and issue rulings in favor of Russian parties. It's also been relied on to actually issue anti-arbitration injunctions against the arbitration that is proceeding under the arbitration clause in the contract. One very infamous example here is the Wintershall v. Russia arbitration. I think it may have been mentioned before. Very briefly, Wintershall was a German oil and gas company with assets in Russia. Those assets were expropriated by the Russian states. Basically, Wintershall was ordered to transfer them to Gazprom, the Russian oil and gas company, because Wintershall was a Western company. That was really the basis for the expropriation. And so Wintershall brought investment treaty cases under treaties containing arbitration clauses And what Russia did is it went into Russian court, and on the basis of these provisions that I've described in the arbitration code, asked the Russian court to impose an anti-arbitration injunction, which the Russian court did. And it also imposed a staggering 7.5 billion euros for if the arbitration was to proceed in violation of that injunction. So really, really difficult situation for Wintershall and its counsel and the arbitrators, because the penalty applies to all of them. There's also opposite situations. There's a case, the UniCredit v. Ruscam Alliance is a case where UniCredit, the foreign party, obtained an anti-suit injunction from the English courts after the Russian party had brought a case in the Russian courts asking the English courts to injunct the proceedings in Russia. The Russian court continued with the case, and in that case also the Russian party asked the Russian court to impose a penalty on the foreign claimant should it proceed with the foreign proceedings in the English court, which again was granted. And in that case, UniCredit itself actually went back to the court, said, I want to avoid this penalty, can you please revoke your injunction? Which the court did. So a host of cases here. I've only given a few examples, but I need to turn to the next issue in view of time, and that is the issue of the non-participating respondent. Again, in a number of Russian cases, we have seen Russia not appear, and there's been other cases where respondent states have not appeared. One is, for instance, a PCA arbitration that was initiated by the Philippines against China in relation to territorial claims over the South China Sea, which has very significant oil and gas resources, and China claims sovereignty over that territory. And after the Philippines initiated an arbitration under the Treaty for the Law of the Sea, the Philippines rejected the arbitration and failed to appear. Now, in all these cases, of course, we have the well-known solution present in all arbitration rules and virtually all arbitration statutes around the world, that the tribunal may proceed with the arbitration and issue a ruling in absentia, and that is exactly what has been happening in these cases. A fourth issue, and I would say, unsurprisingly, the pièce de résistance of procedural issues in these cases is, you will guess it, tribunal constitution and arbitrator challenges. Again, here I have to mention Russia, because Russia has really been emblematic in the number of attacks that it has raised against arbitrators of Western countries on the basis that these arbitrators are fundamentally biased against Russia. That was the case in Wintershall, the case that I already mentioned. Another example are two cases where one of the arbitrators, or two, had signed the endorsement, had signed the March 2022 declaration of the Institute of International Law criticizing Russia's actions in Ukraine. Russia claimed that by signing that declaration, the arbitrator showed bias and challenged the arbitrators. In one of the cases, that was a state-to-state case, and it had a 5-member tribunal, as is typical in these cases. In that case, the 3 unchallenged arbitrators decided the case in favor of Russia, and the arbitrators were disqualified. In another case, an investor-state case, the challenge was decided by the chair of ICSID, and he decided differently. He said that the mere signature of the declaration did not indicate bias, and that as long as there hadn't been any particular showing of bias in the issues in the case, the arbitrator should not be disqualified. It's interesting that the outcomes in these two cases was different. Just one other example, just this month, the Russian prosecutor has asked the courts to basically put a life ban on Charles Poncet, serving as arbitrator in Russia-related cases. Mr. Poncet was the claimant appointed arbitrator in the Wintershall case. He was also the claimant appointed arbitrator in the UCAS arbitration, in which Russia was held liable to pay $50 billion in damages, which I believe is still one of the highest damage, if not the highest damage award in the history of case law. And he had also sat in another case. Now, I will say, in fairness to Russia, some of these challenges may have some merit. I've been at a number of events with parties, with counsel defending Russian parties, and it is true that it is tricky in these cases, and in cases sometimes generally, to find arbitrators that you, as counsel to a party, feel are not predisposed. How am I doing on time? Good?
We're kind of at the end, but carry on.
All right. Very quickly, so the fifth issue that I raised was, in some cases, it's even a question, who is the valid representative of a state? Sometimes, in times of conflict, there are periods of uncertainty, and so these are practical issues that arise in cases. There's one case involving Venezuela, the Mobile v. Venezuela case, where at the time when Mr. Guaido was being recognized by a number of countries around the world as the valid president of Venezuela rather than Mr. Maduro, a representative of Mr. Guaido asked the tribunal to recognize him as the valid representative of the state and not the representative appointed by Mr. Maduro. That was a tough challenge for this tribunal to decide. The tribunal took a pretty practical solution. It held that this was a procedural issue within its jurisdiction under Article 44 of the ICSID Convention, and that it was not a decision on which government was the legitimate government of Venezuela, but that the tribunal just had to decide who was going to pursue the case before it. And it did decide, in light of a number of factors, including that the case was very well advanced and had gone through a number of procedural stages before, all of which had been handled by the representative of Mr. Maduro, to decide that he should continue to represent the state. I'm also personally aware of Libya having had that problem in a number of cases where different parts, different entities lay claim to being in charge of the country, and tribunals having to decide who is going to appear on behalf of the state. And my final point was, as I said, on evidence gathering. Here, two quick issues. One, of course, evidence can be critical in these cases, and evidence can disappear. So an important issue that some tribunals have faced is whether to issue provisional measures to make sure that the evidence is still there when it needs to be presented. That has been done in cases involving the claims of persecution of the Rohingya minority in Myanmar, and also in relation to the Syrian civil war. And then finally, sometimes showing certain things can be really important. Those who act as counsel in these cases know that very well. One example that I wanted to mention here is the Stabil v. Russia case, which relates to Russia's occupation of Crimea, where certain paramilitary troops occupied assets of individuals of Crimea, and the claimant could not show direct evidence that these paramilitary troops were basically being ordered by and under the authority of the Russian state. And in that case, the tribunal accepted indirect evidence and presumptions to consider that fact proven. And that is something we've seen more generally in these cases. Tribunals struggling with what can be the means of proof. Does it need to be direct or indirect? Who has the burden of proof? Does it shift? What is the appropriate standard of proof when on the one hand it can be so difficult to gather evidence, but on the other hand, very serious claims are being made that tribunals want to be sure they are proven before holding in favor of the party making the claim. And that brings me to the end of my presentation.
Thank you. I have a million questions, but I'll save them for the end. One point I did want to note is I think the Venezuela example in particular is interesting, the issue of the different potential leaders, in part because if I recall correctly, the US court was asked to determine this question at some point as well and took the view that it was a political question, had to follow the executive. So it ended up that you had different tribunals going in a few different ways, and then you had the US court weighing in as well, and it just really added to the already well-documented complexity of the situation. Okay, well then, with that, we'll hand over to Andrew to walk us through the final stage of the arbitral process, so enforcement and execution, and how these issues arise there. Andrew.
Thank you, Paris, and thank you, Professor Berman and other members of the organizing group of Columbia Arbitration Day. I'm very happy to be here and honored to be with this distinguished group of panelists. So the question that I was asked to discuss is, how has conflict impacted enforcement of arbitral awards? And I think the answer is, well, it hasn't made it easier, that's for sure. And I want to really focus, I mean, there's a lot of aspects you could come at this question at, but I really, one is investor-state disputes and awards and how those are addressed. But I'm not actually going to touch much on that issue. There's much to be discussed on that issue, but I actually want to focus more on commercial arbitral awards and what role and what issues arise with respect to the New York Convention, and particularly in the United States. As folks who are practitioners and arbitrators here likely know, the United States is one of the most popular places to come with your international arbitral award because the United States typically has touched on so many commercial transactions of so many parties, and also if a counterparty against whom you have an award happens to transact in US dollars, you might hope that those US dollars somehow touch the United States at some point, giving you potentially an option to attach a debtor's assets or go after those assets in some way. So it's very common in the United States, oftentimes here in New York or in Washington, D.C., for parties to bring these international arbitral awards here and seek enforcement under the New York Convention, which is typically supposed to be a very summary proceeding in order to convert the award into a New York or Washington, D.C. or other court, U.S. court judgment, which then you can go out and try to attach assets and try to actually get recovery off of your arbitral award. And so the issue has come up in the last several years, including a decision most recently earlier this year in the District of Columbia on, well, what happens in the scenario that has been touched on by Daniel and Ank in their presentations of how do sanctions impact that? I mean, that's the most tangible, in many ways, tool that is coming at and interfering in some way or interacting with commercial international arbitrations where one party on one side either was sanctioned or becomes subject to sanctions, and how that is going to play out in an enforcement proceeding. So the New York Convention, as some of you know, has limited exceptions to enforcement. One of them is if recognition or enforcement of the award would be contrary to the public policy of that country. Well, perhaps unsurprisingly, parties who are facing an arbitral award, either awarded to a sanctioned party or the other way around, want to use those sanctions to say, well, you can't enforce this. You cannot enforce an award that would implicate U.S. sanctions or even other sanctions, but particularly U.S. sanctions. And for a U.S. court to do that would actually be contrary to the public policy of the United States. And interestingly, there was recently a case in Washington, D.C., where a Russian party, it was a private party that was in an arbitration with a non-Russian party. The non-Russian party obtained an award against the Russian party, but subsequent to the main performance of the underlying contract, the Russian party became subject to U.S. sanctions. And so when the time came for that award to be enforced and recognized in a U.S. federal court, the Russian party said, well, wait a minute, no, you can't enforce this because it's against public policy of the United States. And interestingly, the U.S. government, the Department of Justice through the Solicitor General's office, sort of partially weighed in and essentially punted on the issue and said, well, we're not going to take any position right now on whether recognition or enforcement under the New York Convention and the Federal Arbitration Act of a foreign award in U.S. court where one of the parties is subject to sanctions would itself be violative of public policy or the sanctions, but just warned the parties and said, well, if you do get this enforced, you're going to have to get a license to go forward to do anything other than get a judgment from a federal court. You cannot go and take that judgment and actually seek to attach any assets of the sanctioned party. And the court in D.C., this was in January actually, found that the court could recognize the award under the New York Convention and that the public policy exception under the New York Convention is supposed to be quite narrow. It's supposed to be for things that are, I think the term is like repugnant to the policy of the host state of the U.S. in this case, and that because the U.S. government had not come in part and said that they felt strongly that this would violate U.S. policy, that the court would allow the recognition of the award, and that creditor party who had the award got a judgment from a federal court. Of course, they can't really do anything with it without the license. And that actually takes me to this license issue, which has come up before. And I see Peter Pettibone in the audience, and we've had some back and forth on this related to this, actually. The U.S. sanctions regime with respect to arbitrations is actually very complex, not straightforward, and not that easy to navigate around. And so prior to this 2026 case, there was another case, a case that involved a Ukrainian party, and this was around the time of the Crimea War when initial sanctions under the Obama administration were put into place. And this was a case involving Forbes, and Forbes had a Ukrainian licensee or licensor who was using the Forbes name in Ukraine and then misappropriating the Forbes name in the Ukraine. So Forbes brought an arbitration because they had an arbitration clause in their licensing agreement to try to preclude and get an injunction against the Ukrainian entity. And in order to even get the injunction, and even before they went to go enforce a final award, the parties had to go to OFAC in the United States and try to seek and ask them, could the arbitrator even issue such an award when this party is subject to sanctions? And can there even be party representatives involved in this whole arbitration? And the initial answer, although there's some nuance here, that no, there has to be a license for an award to issue was actually the suggestion, and also for the party representatives to go forward. And in that case, the parties actually did get a license. They went forward, and there was an enforcement proceeding in New York, and This was in 2017, I believe. And the court, again, relied on the fact that there was a license to allow for the enforcement of the award in the United States. And this is actually borrowing on frankly, Ank's topic on interference with proceedings and how these global conflicts play out. But currently, and for the last several years, and Peter has informed me of this, and I've learned all about it now, is there's been an effort to try to get a general license in the United States for arbitrators and counsel to be able to freely participate in private commercial arbitrations involving sanctioned parties, similar to how the U.S. and OFAC has has issued a general license for counsel in U.S. courts to do the same if they're representing a Russian party or they're representing another sanctioned party in a formal proceeding or court proceeding. They can do so, but in private commercial arbitration, there is no such general license, and there's ongoing efforts to try to get that license, a general license. But currently, it is a ad hoc system to try to navigate that issue, and obviously that creates real practical problems. Now, it does seem that in certain circumstances, OFAC will give you those licenses, but it's really anybody's guess, and probably might depend on the administration in place and all sorts of political issues and lobbying efforts to try to get that issue resolved, including for the enforcement phase. I mean, to me, it's quite arbitrary, and it adds to the uncertainty and the impact on whether private commercial arbitrations that you might need to come to at least a U.S. court to enforce are really going to be effective when you have parties who are subject to potentially being sanctioned or in a conflict region that may give these issues where one of the parties who loses could always claim, well, if they're from a country that is at that point viewed as adverse to the United States interests, could that be a grounds under the New York Convention to prevent enforcement? As I said, luckily U.S. courts so far have said that shouldn't be a valid reason not to at least get your initial New York court or other federal court or state court judgment in the United States. But that is by no means set in stone, I would say, given the nature of the public policy exception in the New York Convention. And I also think, although I'm not at all an expert in EU law, the EU regulation is trending, I think, toward the opposite direction of being more formalistic in that they will prevent parties from sanctioned parts of the world from coming anywhere near an enforcement proceeding in an EU court. So all this to say, I think that I echo what the other panelists say, is that it seems like with conflicts in various regions of the world, we're moving a little bit toward a more a more separated regional world where perhaps the old way of, well, I have an international award, I can use the New York Convention in 160 plus nations, will not be as certain as perhaps it was prior to years ago and prior to the current global conflicts.
Yeah, definitely. And I think that the change in attitude to states paying these awards is only compounding the problem. Okay. Juliet, am I right in thinking we're supposed to end at 4:15? 4:20. Okay, so we have 10 minutes. Let me, before we hand it over to questions from the audience, just ask one question that I'm not sure we've yet touched upon as a panel, which is, what are some key considerations for parties and counsel engaged in disputes, these kinds of disputes? Are there things that parties and counsel should be keeping in mind? So I'll hand over to Andrew first to kick us off.
I would say you have to be flexible and be willing to think outside the box and not necessarily expect that the prior path that others had taken will work in all circumstances, because it may not. I mean, there's so many different aspects that go into these conflicts, And I think it's important to take a step back and think, where are we going? If you're advising a client, at least from my perspective, you always have to think about what the end game is of if you're going to initiate an arbitration. Is this going to be some sort of Pyrrhic victory at the end, even if you're absolutely right? Or is there other paths that you need to take, including potentially in the sanctions world, political lobbying, or figuring out how you're going to actually be able to potentially achieve a better outcome for a client than otherwise. So I think flexibility is the key thing that I think of in this, in a world of conflict, to be able to try to navigate as best you can.
Yeah. Anyone else from the panel have anything to add?
Happy to jump in. For me, I think one of the issues that is going to really be front and center for conversations with clients revolves around dispute resolution clauses, and particularly around selection of institutions and seats. So when a client is dealing with a counterparty that is in a jurisdiction that is either sanctioned or potentially may be sanctioned in the foreseeable future, I think there's a real conversation that needs to be had. As always needs to be had, one always has to look at the context for what the counterparties in a transaction are when looking at seats in particular. And I think that there's, we used to kind of just think, is this a pro-arbitration jurisdiction or not? And I think it's become a much more complicated analysis. And certainly with the Chinese counterparty, there are certain considerations. With the Russian counterparty, there's certain considerations on the seat. And same goes for the institution. Some institutions have really handled sanctions better than others. The LCA particularly was front and center in getting itself a general license early, and the UK gave it to them. And the situation, as Andrew was describing with OFAC and getting a general license for arbitration in the US, it's an effort that many of us in the community have been. I see people in the room who have been involved in the New York City Bar Association in efforts for several years to no avail. So it's for no good reason other than that there's not the political will to do it. And you add to that our sanctions regime, there isn't even one approach. Each there's multiple sanctions regimes for different countries. Each one has a different approach to dealing with arbitration. So you really have to, and if you're approached as an arbitrator, how could you possibly take a case? First of all, you'd have to spend probably 100 hours of research getting into the details of different OFAC regulations, and you still wouldn't have the certainty of whether you could proceed in time to take a mandate. So that's a real issue, but that's an arbitrator problem. Thank you.
Yeah, think ahead, protect yourself. I think that's more maybe advice to our transactional colleagues, but I think it is very important advice in today's world. These types of issues are not going to go away. They are going to become more prevalent, and so think about investment treaty protection. Think in your contract to insist on a foreign seat. Most of the times where arbitration goes wrong, it's because the seat is not in a neutral country. It's very basic, but it is as important as ever and more important in these types of situations, I would say. And then another one that I would say is select the right arbitrators, and I think arbitrators are becoming more and more key. Like when you look at a situation like the Wintershall case, I do not envy the arbitrators who are sitting in that case, and I think there are more and more arbitrators around the world who think very carefully before they accept certain appointments, because they know in certain cases issues may arise, and that is an issue. That is a threat to the rule of law if nobody wants to act in cases involving certain countries anymore. So it's very important. I did a keynote speech about this last year somewhat, and one question that I raised was insurance for arbitrators and whether arbitral institutions should be thinking about taking out more general policies for their arbitrators. I didn't make myself necessarily very popular with the institutions with that comment, but I do think it's something we're going to have to think about more in the years ahead.
Anything to add, Professor?
I'll just quickly say, I think for counsel to be creative, as you say, and thoughtful in advance, but also in the way they frame their arguments. I think in a lot of these cases, arbitrators would be quite happy to decide on the narrowest grounds possible or on procedural grounds. So when you mentioned the Moderator case, well, this is a procedural issue. We've been going along this way for a while. We'll continue along that route. I think that will be attractive to a lot of tribunals who don't want to make sweeping decisions or decisions that are perceived as sweeping about recognizing one government over another, but will be looking for what we might call off-ramps to make a cautious decision. So I would say, give your arbitrators that opportunity when you can, if you're a claimant anyway.
Thank you. So I think we have around 5 minutes left for any questions from the audience. Yes, at the back there. A microphone should be nearby.
Thank you. What do you think about the practice that we're seeing of arbitrators including in the terms of reference and in the terms of appointment arbitration clauses for claims by the parties against the arbitrators? That's a solution that I've seen in a number of cases because of the difficult jurisdictions that you're mentioning.
Yeah, so the question was about, in terms of reference, having some sort of agreement that the arbitrator would have immunity.
An arbitration clause to resolve disputes. That's what I understand. Exclusive.
Yeah, the clause would basically say the rules for immunity of arbitrators. Arbitrators will be liable up to whatever the standards the parties agree to, but there will be an arbitration clause for claims by the parties against the arbitrators with a neutral jurisdiction like The Hague or Paris, and rules that may be different from the rules of the arbitration itself.
Well, you're going to need a lot of insurance, I think, to Ank's point, to pay for another arbitration. I mean, I suppose it's a better than the alternative potentially of, or at least the arbitrator or the party who's opposing somebody who's going after an arbitrator, at least would have then an argument to get out of a national court that might be more hostile. But my initial reaction is it would also be quite costly for everyone involved, including the potential arbitrator, to have to face, it would just give another venue for a disgruntled party, I think, to go after the arbitrator.
I haven't seen it before. It's creative, that's for sure. I've seen more clauses trying to establish absolute immunity, and it seems somewhat in tension with that. So it's interesting that arbitrators would even acknowledge that there might be a claim against them. My reaction is quite positive, actually. I think it's an intriguing idea. It does raise questions of cost, and I want to think about it a little bit more. But I can see why. We have seen, of course, several instances of arbitrators being pursued before courts. Very often, personally, and very aggressively so. So I think I like it, Eduardo, is the answer.
Yeah, to me, I think kind of thinking the way Andrew's thinking, if I have a client that's particularly disappointed with their outcome, and there's a clause in there that gives them an avenue to give the arbitrator or arbitrators a really hard time. Clients have a lot more resources than arbitrators do, so I think it could spiral out of control.
But it's really to avoid claims in courts, right? So it's to prevent the harm, but I think you're saying it might actually create more harm.
I would also think that it would be better if the institutions imposed it rather than trying to get party agreement in terms of reference, just because I have had a situation where there was a sole arbitrator. It was an arbitration seated in Sweden, which did not have automatic immunity for arbitrators, and the opposing party was a state that liked to use red notices against their adversaries. And when the arbitrator asked for an immunity clause in the terms of reference, the state party refused, which led to his prompt resignation as the arbitrator and delayed things quite a bit. So it's because, once you propose it and then one party rejects it, I think the signal is in for the arbitrator that you want out of that situation quite quickly.
Do we have any other questions from the audience? Professor Berman.
The topic you're discussing obviously implicates arbitration, but it seems to me that given the nature of this subject, the substantive terms of a contract might really matter. So you suggested careful choice of seat, I assume careful choice of applicable law, careful choice of arbitrators. Now this is not really your job to draft the contracts as a whole, but do you have any insights as to how a contract could be drafted to begin to address substantively some of the challenges you've been talking about? Just for example, is a force majeure clause something that should be given more attention to, or I don't know. This is maybe not a fair question to those who think mainly about the arbitration clause, but it seems to me you might get more involved with your transactional lawyers if you're really worried about these things, because they may come back to haunt you in the arbitrations that you have. Now, this may be something you can't or don't want to answer, but I think it would be a good idea if these kinds of situations are to be anticipated, and I agree they are. Do you imagine finding yourself becoming more involved in the drafting of the contract? Because the terms of the contract may factor in to heightening or lessening the risks. If there's any thoughts about that, I'd welcome them. But I think it might be desirable anyway. You could leave it there if you'd like. It might be desirable to think about contract drafting a little more broadly than we customarily do as arbitration practitioners. I'm just guessing about that, but I want to put that on your radar screen and see if it makes any sense to you. Ank, I think you have something to say.
Doing my job, Professor Berman.
It's a good point. I think you should come do some marketing at the White case and law firms more generally to convince our transactional partners they should involve us more, because I do believe we could have very valuable input in that way. We do get involved in the drafting of the dispute resolution clauses. We do at times get involved in more substantive questions, and I think you're right that when advising clients on a transaction that involves going into a jurisdiction that is a risky jurisdiction, I can certainly see our transactional colleagues thinking about that, and I have advised on force majeure clauses and the like. So I think it's it's a good suggestion, and it's something that we should be doing a lot with our transactional colleagues. When something comes in, very often you get to just look at clause 10, and then you have to go back and say, I do want to make a comment on clause 8 also. Some of them are very appreciative of that, and others are like, no, just stay in your little box then. And yes.
But it will impact you when the arbitrations happen, and the outcomes may vary according to how the contract was drafted.
Very significantly so, yes.
Absolutely. I fully agree with what Ank said. And when transactional lawyers come to me with their disputes clauses, I view that as an invitation to look beyond the clause. And because, as you said, Professor Berman, we would have to defend the contract as a whole. And certainly there are issues that our transactional colleagues sometimes might not encounter. Particularly, it comes up with state-owned entities, and where we have to think carefully about issues of enforcement and sovereign immunity, but more broadly on the issues we're talking about around conflicts. Of course, force majeures need to be thought about carefully, absolutely, but I think especially with certain jurisdictions at play, reps and warranties need to be thought about. One could cover reps and warranties to address sanctions issues. Material adverse change provisions could also be at play. And one other thing that I think is especially in a jurisdiction that's prone to conflict, where force majeure is almost foreseeable, and there's a question as to whether you could even have a force majeure. But I think cost sharing is sometimes needs to be raised so that one party's not saddled with all the risk in a force majeure situation, and the parties have a real conversation about how they would share the risks and the consequences of those risks.
Yeah, and I'll just add one more clause that I know has come up and I've seen and advised on is change of control type clauses where you're dealing with entities or a business that may become state-owned, or you might think there's a risk of it becoming state-owned voluntarily or involuntarily in the future, and how that plays out is an important thing that you can consider in advance. Whether it works, that's another question, but at least think through those issues, which, those arbitration clause adjacent clauses that come into play.
Just very briefly, I think it's, obviously it's a great idea, and in particular, it seems that for the most part in sanctions cases, and you all might know this more than me, but sanctions have not been treated as force majeure. They've been treated as applicable law and potentially overriding mandatory rules, et cetera, with all of that discussion. But it might be that if somebody wants it to be force majeure, that should be made very clear.
Well, our time is up, so thank you all for listening, and please join me in thanking our panelists for a fantastic discussion today.